Good afternoon. My name is Becky Young. I am managing partner at Grossman, Young and Hammond, an immigration law firm in the Washington, D.C. area. And I'm very excited about today's webinar. We're going to talk about the USMCA, at least that's what it's called from the United States side. I have three experts here with me, and I've always personally been really curious about the differences in this trilateral treaty and how it's implemented and interpreted in each country. So I have here with me today Raul Laramais, who's a partner at EC Rubio, a law firm in Monterrey, Mexico. Jacqueline Bart, managing partner of Bart Law in Toronto, Canada. And Sophia Hassander, Global Immigration Counsel with Grossman, Young and Hammond, my law firm here in the Washington, D.C. area. I have worked with all of these fine lawyers for over a decade, and so I can assure you that the depth of their expertise is high, and I think we should just dig right in. The format today, we have a number of questions. We're going to I will ask each question. I'll give each panelist 2 minutes to talk about how that question might be addressed from the perspective of their country. And then hopefully at the end, we'll have a little time. We'll do our best to leave a little time for Q&A. So let's get started. So the first question is, how frequently are USMCA, and I'm going to use USMCA because we're in the US, but you can maybe, Raul and Jacqueline, start off by explaining what the treaty is called in your country. How frequently are these categories used in your country for professional or business mobility? And what are the benefits compared to other visa options? So let's start with Raul and then Jacqueline and then Sophia. Take it away, Raul.
Sure. So in Mexico, it's the T-MEX, but we all call it USMCA as we are speaking English. The truth is that in Mexico, in 2012, there was a very hefty immigration reform. And through this reform, immigration is now very much linked to how much time you're going to spend in the country, whether you're going to be paid from Mexico or from outside of Mexico, and that's it. So the categories for USMCA did not change because they're still based on the time the foreign nationals will remain in Mexico and whether they will be paid outside of Mexico or not. So no changes in requirements for us. But the visa process is pretty simple, and we'll explain it later.
Great. Jacqueline?
Yes, well, we call the USMCA the CUSMA, the Canada-US-Mexico Agreement. So the CUSMA we utilize quite frequently in Canada. We love the CUSMA. We think it's an incredibly useful tool because it's much more facilitative. The benefits are exponential in comparison to other types of alternatives. It's one of the more facilitative free trade agreements, certainly much more facilitative than the CETA, which is our European free trade agreement, and the UK free trade agreement as well. Although we do have other free trade agreements that have some benefits that the CUSMA does not have. But in terms of utilization and benefits, the beauty of this particular agreement is that we can bring in American scientists and many different types of professionals to Canada without having to go through a labor market impact process or to find another alternative, which may be much more complicated. We can actually obtain work permits for scientists and professionals from the United States as well as Mexico and have them in Canada in as little as 48 hours. For Americans. For Mexicans, we do need to do visa processing for most work permits, and we'll be talking about that a little later. It's also a wonderful category to bring in people to Canada based on short-term business options, such as after sales service. So I'm going to be delving into that quite a bit later. But what I did want to mention is that we do have 500 different work permit categories, plus or minus, in Canada. And given the fact that we'll immediately reach for the CUSMA whenever we're dealing with a Mexican or an American to see if there is an opportunity for them prior to looking at the other 480 options, is an indication of how important this particular category is to us.
All right, we thought we had a lot of categories in the US. Sophia, tell us your thoughts about the USMCA.
Yeah, from a US perspective, the USMCA visa categories, similar to Canada, are very popular, especially the TN and the L1, as we refer to them here. They're widely used for professional mobility for Canadian and Mexican professionals who want to come and work in the United States. And especially the TN professional visas are valued similar, like Jacqueline mentioned, for speed and predictability compared to the other options that we have. I wanted to mention just a couple of comparison points with the H-1B, which is the other main professional visa category that we have here in United States. So one big positive with the TN is that there's no cap. The H-1B only has a certain number available per year, and they're all only available once per year. So it's essentially a lottery that you have to win. The H-1B also has a higher processing burden where you have to file a labor certification application with the Department of Labor. You don't have to apply to the local immigration agency first, the USCIS here. Canadians can go straight to the border and apply. Mexicans can apply at the consulate. There's also no required minimum compensation similar to that of the H-1B, where the Department of Labor essentially sets what the minimum wage has to be. And there's also no max time in the United States. In US, the H-1B, you can be max for 6 years, but the TN you can keep renewing.
All right, so that's USMCA 101. There are 4 main categories. Sophia mentioned the TN, the L1, the business visitor, and the e-visa. So we'll touch briefly on all of those. The TN is the one that we see the most of in the United States. And so this is kind of a long question. I'm gonna say the whole question and then ask you guys to do your best to address it. So we would like to talk about the TN. What are some of key eligibility criteria for the TN? How do employers ensure their job offers align with the professional categories that are recognized in the treaty? Any categories that are more challenging? What's the process in each country? And how do border application privileges or consular requirements affect speed and strategy? So that's a lot to cover in 2 minutes, but please do your best. And again, I'm just going to go on the order of my screen. So Raul, if you could talk about the TN, whatever what you call that category in Mexico.
Well, it really depends on the time that the foreign national will remain in the country. If it's less than 180 days, they will enter under a visitor visa. For US and Canada, visitor visas are granted at the port of entry. The only real requirement is maybe proving that you have an invitation to come into Mexico. If the foreign national is going to be paid through a Mexican entity or will remain more than 180 days in the country, then they will need a temporary residence visa. And that process is very similar to the L1 process for Mexico, which is we need to submit first in Mexico for an employer certificate, which is just registering the company with immigration. Then we need to request a visa for the foreign national. This visa is requested at the National Immigration Institute. Once it's granted, the authorization is sent to the Mexican consulates abroad, and the Mexican consulates abroad will issue the visa. And after that, the foreign national must enter Mexico and attend to the National Immigration Institute to change that visa for the final immigration form, which they must do within 30 days of entering the country. So it's a lot of steps for the process, but it's a simple process with few requirements. If the foreign national will not be through more than 180 days, they can skip the employer certificate and requesting the visa process in Mexico, and can request a visa directly at the Mexican consulate abroad, which facilitates the process. They would still need to travel to Mexico within 6 months, and upon entering Mexico, they have 30 days to change that immigration visa for the final immigration form. So it would be the temporary residence form. And those are the key immigration forms that are used in Mexico.
Thank you. Jacqueline, how does this provision work in Canada?
Yeah. So we call it the T36, and the T36 provision is, we love it. It includes all sorts of professionals, accountants, architects, engineers, hotel managers, industrial designers, technical publication writers, and a whole host of scientists, including a dairy scientist, including an oceanographer. So it really does provide a tremendous amount of options, and probably the most interesting of these options are the physician option, which doesn't allow for practicing. So for physicians from the US and Mexico, unfortunately, we actually have to get them a labor market impact assessment based work permit, because they can only enter under the T36 to teach or to research. Another category that's a little bit more complicated is the scientific technician technologist category. There's a lot to show. We would have to show that basically the national occupation classification is correct and matches the job description as well as the resume, and to show work in direct support and supervision of professionals, we would have to show a list of, basically show that they qualified based on the list of qualifying professionals, which is agriculture, science, astronomy, biology, chemistry, engineering, forestry, geology, geophysics, meteorology, or physics. And they will have to show that they are being supervised, and remote supervision could be problematic. So one of the questions is, where's the supervisor located? Same with the management consultant T36 visa. It's quite complicated for various reasons, which we really don't have time to get into. But basically, a management consultant has to demonstrate that they are providing consulting to management on the improvement of operations of an organization. And so no actual execution of the work or actual managing of people is allowed under that category. But there's various permutations of that category. There's a number of problems with the category if the person can't be employed in Canada and they want to eventually immigrate to Canada. So that's an issue as well. But unfortunately, there just isn't sufficient time to go into all the nitty-gritty of the management consultant category. But needless to say, it's a complicated category, but it's worked very well for both temporary entry and for permanent residents. In terms of the way of applying, it's a bifurcate system. It's a quick system for Americans, but it's bifurcate. And when I say bifurcate, that means that there's employer application and there's an employee application. So the employer has to apply and be receipted for the employer compliance filing, the employer commitments that the employer is making to the government of Canada. And once all that has checked out, then the employee can apply at the port of entry, the American national. When we're dealing with Mexicans, generally speaking, Mexicans would not be able to apply at the port of entry, certainly not at a border entry. They would need to do visa processing through the Canadian consulate in the US or at the Canadian embassy in Mexico. So as you may know, the rules for Mexicans entering Canada are a little more complicated these days. And so you can apply for ETA, which is a special entry that doesn't require a visa, but in order to do so, you either have to hold valid non-immigrant status in the US, or you will have had to have held a Canadian visitor visa, a temporary resident visa in the past 10 years for Canada. And that's only to enter at the airport. So for more flexibility, obviously, visa processing does make a lot of sense. And visa processing is actually quite efficient through the Canadian embassy if it's done properly. And so that's the best route to apply for a T-36.
All right. Thank you very much. Sophia, Jacqueline mentioned a few categories, management consultant and scientific technologist, that I know are also challenging in the US. What else would you like to add from the US perspective?
Yeah, management consultant, we see the same issues. They want to see that it's a supernumerary position, that is it's not someone who's coming in to take a job from a US worker, but coming in to consult. So we do tend to prepare those very carefully. Another one that I wanted to mention is economist. It used to be possible to pretty much fit any financial related occupation or job under that category. But there was a USCIS policy memo that came out in 2017 that narrowed the interpretation of economists. So since then, they're now scrutinized much harder. And this policy memo actually specifically mentions that financial analyst, market research analyst, and marketing specialist do not qualify under this category. So that was the one I wanted to highlight.
All right. Thank you. Let's move on to business visitors. So this is another category that's widely used. How does the USMCA facilitate the movement of business visitors in the US, Canada, and Mexico compared to other visa categories? What are the scope of permissible activities? And particularly, I think that one of the most interesting one is short-term work-related travel and after-sales service. What are the limits of this category? Raul, what can you tell us about business visitors under the USMCA to Mexico?
Well, as we mentioned earlier, business visitors that will travel to Mexico will not receive salary from a Mexican entity or through a shadow payroll or mirror payroll type tax strategy, can enter Mexico and receive a visitor visa at the border. Since, as I mentioned, the law changed in 2012, the activities that can be performed under each category makes no difference. So a foreign national under a visitor visa can perform any type of work activities in Mexico. The only issue is not receiving salary from a Mexican entity. If they will receive salary from a Mexican entity, then it cannot be considered a visitor, and we would need to process a temporary resident visa and form. However, the visitor visa, as long as at the port of entry, we correctly state what we will be doing in Mexico, that is not confusing tourism with business or with technical after-sale activities, etc., then we will be fine, and that immigration form will allow us to stay in Mexico up to 6 months or 180 days, performing this type of after sales activities, business type visits, or really any type of visit or any type of work. In Mexico, it's also important to mention that after the 180 days, the foreign national can leave the country and can return and receive a new visitor visa form. So it's not limited to 180 days a year. It's only limited to 180 days per visa. Obviously, if we're going to remain in Mexico for longer periods, we do have to consult with a tax expert in regards to whether we are becoming a tax resident in Mexico or not. But that's a different issue. In regards to immigration, there are no special requirements, and many people remain in Mexico as visitors for prolonged periods of time, as long as they leave within the 180-day period.
All right, very interesting. Jacqueline, what is your quick take on
Yes.
business visitors under the NAFTA, CUSMA?
Yes, yeah. So the CUSMA intention for business visitors, and if you look at the appendixes of the actual agreement between the three countries, business visitor activities were allowed. Mexicans and US and Canadians should be able to travel to each other's territories to engage in technical, scientific, and statistical research, and independent research, to come in to supervise harvesting and marketing and conducting independent research and marketing and an analysis, attending trade conventions, and promotional personnel should be able to enter. Same with salespeople. Distribution, all sorts of activities were included. I have to be honest with you, the reality is that in order for people to come in to do these kinds of jobs, they can't come in the way that the agreement sets it out. They actually need to get short-term work permits for most of these activities. And the reality is that these short-term work permit, they're actually work permit exemptions, so their work authorizations are based on a completely different provision in our act. But basically, nobody can come into Canada and visit if they're actually working. So if you're working, you need something. You need a package explaining what you're actually coming to do. So it's much more restrictive than the NAFTA ever anticipated. And even though in the past we would try to indicate, well, under the NAFTA, under the CUSMA, the NAFTA is the former word, before Donald Trump renegotiated the CUSMA in 2017. But the CUSMA, and no changes were made, by the way, to the international mobility provisions. So the agreement remains the same as it was in the 80s. So absolutely no changes were made. So yeah, so basically we've got short-term work permit exemptions. We've got after sales service, which is subject to tremendous requirements. So I have to be honest with you and say that the CUSMA is not facilitated when it comes to business entries, business visitor entries, or just any kind of visitor entry, and that's very disappointing.
So I think that in the U.S. side, Sophia might have a different perspective. Sophia, how do you feel that the business visitor provisions of the USMCA are implemented?
Yeah, I think how it works in the US. So the B1 visa is the main business visitor visa for anyone in the world who wants to come to United States for business meetings and trainings and temporary work but where the main work is being happening outside of the United States. So you're just in there for some temporary need relating to your main activity that's outside. So yeah, since Canadians are visa exempt, they can enter, I think, with very few questions at the border to come in as visitors under the USMCA. And the expanded language will typically work so the CBP will maybe allow a little bit more expanded activities than the regular B1. Also specifically with after sales services, which is a big one under the visitor visa, where you can come and service commercial or industrial equipment that you sold to a US company. There's a big difference in that the USMCA mentions also computer software. And the FAM with the Department of State is relying on for B1 acceptance in the rest of the world does not mention computer software. So that's a big one.
All right. Moving on, we're going to talk about intracompany transferees. So under US immigration law, this is the L1 category. How does the USMCA apply to intercompany transferees in the US, Canada, and Mexico? What are the main difference in how each country handles these cases? Raul, do you want to talk about intercompany and transferees in Mexico? I have a feeling it might be similar to
it's the same process for every type of visa. The issues we see with intracompany visas is mainly in regards to the salary. There's always there has to be a tax planning behind this to avoid a permanent establishment in Mexico, and thus determine what type of process is best for the foreign national, whether requesting a visa directly at the Mexican consulate.
And Raul, sorry to interrupt you, but could you define permanent establishment just for those who may not be familiar with this tax concept?
Okay, yeah, well, I'm not a tax expert, but if a company, a foreign entity in Mexico establishes a business in Mexico, and that business is set to benefit the foreign entity directly, the tax authorities may determine that that foreign entity is taxable for Mexican purposes, and the taxes for those purposes are very high, and can tax a large portion of the business that is being performed within Mexico and the U.S. So avoiding a permanent establishment is essential in order to be able to transfer foreign nationals to and from Mexico. So most of the times, the strategy will involve a foreign national being an employee of the Mexican entity, whether it be directly through hiring them at the Mexican entity, whether it be through a mirror payroll or shadow payroll type tax scheme where the salary is paid through the U.S. but reported for all purposes to the tax and Social Security authorities in Mexico, or a mixed payroll where we still pay a certain salary in the foreign entity and a specific salary in Mexico. However, having the employee as a Mexican employee is usually ideal, and therefore the whole process is needed where a company has to register for an employer certificate, has to request a visa, has to go through the Mexican consulate, and has to then change the visa for the final immigration form, which is a process that, if we have to start from the get-go and we're not a company that's registered, may take a couple of months or more, depending on how the immigration queue at that particular office where we have to file is being handled. So it is very important to plan ahead for this type of immigration forms. Now, there are some companies that have other types of tax structures and pay the foreign national through the foreign entity, and therefore makes the immigration process much simpler.
Okay, thank you. Jacqueline, your take on this category for Canada.
Yeah, so we call it T37 and T38. The intercompany transfer provisions for US and Mexicans are very facilitated by comparison to our normal requirements. Our normal requirements do not allow for intercompany transfers unless it's a multi-country organization. So with US and Mexico, if it's just a company in Mexico or in the US and they're expanding to one country, and that is Canada, an intercompany transfer is allowed. Otherwise, it wouldn't be. So it's extremely helpful, as you can appreciate. The other distinction I wanted to make is for obviously and as there was some discussion already, I believe, the intercompany transfer provisions are to transfer senior executives, senior managers, executives, and functional managers, as well as specialized knowledge workers. And normally we would have to demonstrate that the salary meets the lower income or median income threshold in Canada under the National Occupation Classification for that particular specialized knowledge worker designation. And under the NAFTA, under the CUSMA, we don't have to demonstrate that the salary is commensurate with the National Occupation Classification. Again, a huge difference. There's less scrutiny, and there's a little more flexibility on remote office situations where there's a logical reason to have the foreign worker in Canada as well. These are just a few examples of the beautiful differences between the CUSMA and our regular intercompany transfer provisions. And I could talk about it in greater detail, but the other thing that I really like about Canada is that we can reclaim time. So when you're doing an intercompany transfer, if you want to stay an extra year in Canada because you've been traveling abroad and working abroad at different companies, you can actually reclaim time abroad as time in Canada, which is really nice under the CUSMA, but also on our regular intercompany transfer provisions. So that's a really cool thing.
All right, thank you. And Sophia, we also can reclaim time under the L1 category in the US. What else can you tell us about the L1 category?
Yeah, so for United States, the category is L1 for intercompany transferees. And the USMCA actually does not change the main criteria for the L1, which is, like you mentioned, you have to be an executive, a manager, or have specialist knowledge. And you have to have worked for the same company. Ownership has to be common for the company that you work for abroad, that you come into work in the United States. The main difference, however, is that Canadians can apply for the initial L1 directly at a land border port of entry, or it designated pre-clearance airport. So you don't have to go via USCIS first, which is what nationals of other countries have to do, and Mexicans can apply at the border. It makes it a much cheaper and faster process. And also, you could say probably in most cases, the cases can be a little less scrutinized at the border than they would be if you file with USCIS.
And Sophia, you said this very quickly, so I just want to be very clear. Canadians may apply at the border. Mexicans may not apply at the border. Sorry, Raul.
Yeah,
I'm not the one who made the treaty.
I've known this.
Okay, moving on to the treaty trader and treaty investor. So the E1 and E2 are the categories. There is the possibility to have treaty trader or treaty investor status, but the procedures are different. What are some of the key differences in these visas between the US, Mexico, and Canada? And Raul, again, I'll let you go first.
Yeah, so there is a category for investors in Mexico. It is a very simple process, and it only amounts to how much you have invested in Mexico. And by investment, the government not only not only allows an investment in a company or a business, but also allows having bought property in Mexico, or having enough salary or bank account savings that the foreign national can actually remain in Mexico. So it's very typical, and I know you've known this, that U.S. nationals, Canadian nationals, actually come and live in Mexico from their pensions, and they usually request one of these type of visas. And again, these visas are since they're not going to be receiving any salary per se, are requested directly at the Mexican consulate, and are typically very easy to get. So Mexico has really opened the door so that foreign nationals can come and live in Mexico from their pensions. So yes, there is a special category, not under MCA. It's the same process, not under USMCA, I'm sorry. It's the same process as for any other type of visa, but this category has really populated some remote areas that would be struggling otherwise.
All right, so great to know we can all come and retire in Mexico.
Yes, you can.
I know it's beautiful there. Jacqueline, tell us about the treaty categories in Canada.
Yes, yeah. So the traders are T34. That's the name of the category. Investors are T35. The treaty trader investors, this particular category is only available under the CUSMA. So the law hasn't developed this category beyond the CUSMA for the rest of the world. So sadly. And obviously the traders and investors the traders carry on substantial trade, the investors substantial investment. The investment doesn't have to be made. There has to be a commitment, however, and there's various ways of assessing that commitment. So they're complex categories, and the Visa Office Manual is being updated as we speak. However, practically speaking, we don't particularly enjoy using this category for our clients because processing has to occur at visa offices. And the fact that processing has to occur at visa offices and not at ports of entry means it's not a very expeditious category, particularly right now when the American consulates are so bogged down with applications from Americans that they're having to adjudicate. So what we prefer to do is we try to, if the person doesn't qualify under any of the other categories that fall within CUSMA that we've already discussed, then we try to qualify them under a labor market impact assessment, advertising exempt category if they don't qualify under other categories of our multifarious categories, work permit categories in Canada. So it's not a particular process that's the most desirable for our clients, but we do use it from time to time, and it's a great option to have.
Very interesting. So I just used ChatGPT to find out how many treaties the US has, and the answer is more than 80. So that's a really interesting difference between the US and Canada, which are, I guess we're the only country that has such a treaty with Canada, but the US does allow ease from over 80 countries. But the provisions of Canadian and Mexican ease are governed by the USMCA. So Sophia, let us know what you have to add about treaty traders and treaty investors.
Yeah, and like Becky mentioned, we call it the E-visa here. The E1 visa is the substantial trade between your country and United States. So in this case, Mexico or Canada. And the E2 is substantial investment in the United States. And these are actually very popular categories that we see a lot, especially the E2. It's a good one if you want to come to United States and start up a company. You would typically maybe travel first on a B visa or a visitor as a visitor to United States and get started because you actually do have to commit the investment in the United States before you can proceed. Similar to Canada, here you have to go through consular processing. There's no application at the border for these categories. In Canada, it's the U.S. consulate in Toronto that handles these. There are a few different ones in Mexico. For the e-visa, you have to really look at each consulate's website because the application process varies. So the criteria is the same, but throughout the world, the application in these 80 countries that Becky mentioned, the application process can differ significantly between the different consulates. So you have to look into that. Yeah, I think those were the main points from the US perspective.
All right. So just a few wrap-up questions. The first relates to cross-border comparison. So how do the US, Canada, and Mexico differ in how they implement or interpret the provisions of USMCA on professional mobility? Any notable procedural or cultural differences employers should be aware of? I think we touched on a few already, but Raul, do you have anything else to say on that topic?
Yes, in regards to process, in Mexico, it's very important, and this sometimes becomes a big issue, is that we have to file the immigration process either where the company is located or where the foreign national is going to perform their services. And that becomes an issue because each state may have several immigration offices where it can be filed, or some states may only have one immigration office. And some states are very far from where there are any immigration experts. And the criteria also sometimes changes from immigration office to immigration office. So planning ahead on where we have to file is very important because it may include travel to be able to help our clients in securing an immigration form. So that is very important and different, at least from what I've known to happen in the U.S. And therefore, where we're at and how many offices we have is extremely important for immigration purposes.
That's very interesting and definitely different from the U.S. Raul, I'm curious if your firm and your practice handles these matters throughout Mexico or only in certain provinces?
Well, yep. we have eight offices in Mexico, so we do cover a vast states where we have to file these processes, and we also have a vast list of correspondent firms that help us out. It's impossible to be able to handle immigration matters if you don't have this. And more so now that we have remote workers as well, where you have to file maybe at a beach where it's not easy to get an immigration office, things like that, because of remote work and what's been facilitated after COVID.
All right. Jacqueline, I know that there are some provincial differences in Canadian immigration law. I don't know whether that applies to the CUSMA, but feel free to comment on that or any other aspect of the question.
Yeah. So the CUSMA has actually been ratified into our legislation. It's become part of our legislation. It's become codified in our immigration law and is actual law and is practiced and respected. And we've got the policy clarifications for CUSMA in our visa officer manuals, as well as in our regular policy formulations in terms of how immigration law is practiced. And what I should mention is that there's been an exponential proliferation of immigration law as it affects just, the adjudication of CUSMA, but also just generally. There's just been such a proliferation of rules as they relate to enforcement, the economic benefits, family reunification, and humanitarian visas, some of which do not touch on CUSMA, because CUSMA is basically all about economic benefits, but the enforcement issues apply. Family reunification in terms of spousal work permits applies. Humanitarian visas do not apply, but the rest of the 4 pillars that I've talked about definitely do apply. Provinces are not involved in international treaties. They have no jurisdiction over international treaties. The provinces are involved in attracting their own immigrants based on their own labor market needs, mainly from an immigration standpoint, with temporary extensions of existing work permits for individuals who are already in Canada and are being sponsored by their employers. Yeah, lots of provincial permanent residence categories in Canada, probably around 100 of them.
Wow. Yeah, that's very cool. So Hannah, what would you like to add on this point?
Yeah, I think in my experience, U.S. agencies that process immigration application like to see a lot of evidence. They are pretty strict in their application of the rules, and you have to provide a lot of evidence to be successful. Another important point, I think, is that especially since Canadians can apply at the border or pre-clearances, it can be different between where you hand in your application. So often we like to do our research to see what the history is of specific ports of entry prior to applying or sending someone to apply, and be strategic.
All right. Last question, and then I think we should have a little time if folks have questions. So looking ahead, do you see any potential changes or emerging challenges with the USMCA mobility provisions, especially in light of political shifts or evolving workplace needs in your country? Raul, take it away.
Well, no, I don't foresee any immediate changes. Our president initially threatened to make some changes, particularly to the investor type categories, trying to leverage what President Trump was doing in regards to tariffs. But that was really an empty threat, as I see it. That was definitely not followed upon. So no, I don't expect any changes. I think Mexico right now is more about negotiating and keeping these visa categories. The reason immigration changed so vastly in Mexico is because Mexico was pushing for immigration reform in the US, but had a very strict immigration law themselves. And so it changed because of that, because the US said, well, your laws are tougher than ours. Why should we do any changes? And I think that policy of having a more open border will not change.
Right. Thank you. Jacqueline, what do you see in your crystal ball?
Oh, well, in my crystal ball, well, I think that business as usual is foreseeable. We love Americans, we love Mexicans. We want to encourage and facilitate their entries to Canada. Obviously, the tariffs may affect purchases and sales of equipment across the borders. And so mobility applications for entry to Canada may decline as a result. So that is one issue that I think will arise and affect the CUSMA. The other issue that I wanted to talk about is that there are no tariffs so far on the provision of services. So a lot of the trade is trade and services under the CUSMA. And so that shouldn't affect management consultants and other professionals providing services under the or even after sales service potentially, depending on what sales have occurred, such as software, etc. So yeah, I think the tariffs will have definitely an effect on trader provisions. But the other issue that I wanted to talk about is renegotiation of the CUSMA, because particularly in terms of the list of professional occupations, there's a need for a wider and more generous number of occupations. In Peru, for example, we have a negative list instead of a positive list, and that allows for a whole variety of occupations, and the negative list is based on the National Occupation Classification, so it's completely up to date, which means that the occupations actually exist today, which is a really good thing. So the list of professions that was negotiated in the 80s and was never updated, it's very limited. It's a 1980s list. At that time, period, the list was quite exhaustive. But now the proliferation of occupations has increased exponentially. So, and obviously that list is missing key IT, information technology, and other types of management occupations as well. So there really needs to be an update of the list so it's consistent with our federal national occupation classifications in all our countries.
You make a really good point. You know, when that treaty was negotiated, the internet and email were not even in, you know, widespread use. So that was a different world.
It was a different world. It was the early 80s, exactly. Yeah.
Sophia, what are your final thoughts on the future of the USMCA?
Yeah, no, that's very encouraging with regards to Mexico and Canada when it comes to political shifts. We're experiencing something very different in United States that could definitely affect the processing of visas and immigration benefits, which here we are very much experiencing right now with the current administration, which has very restrictive immigration views, I think it's fair to say. And that does significantly influence how the treaty is applied in practice, and we expect it to. They already, we're just a few months in, we're already seen much more strict vetting at the borders, for example. They've expanded significantly how they look at someone applying to enter the country, but going into social media and see what people are posting, things like that, what we've not seen to the same extent before. And another great example of this is the USCIS policy memorandum that I mentioned earlier that narrowed down the interpretation of economist for the TN visa that actually came out during the first Trump administration. So I think it's fair to say that we would not be surprised to see more of the same during the current Trump administration.
Thank you. I'm going to pause and ask if anyone has a question. Feel free to add it to the Q&A, which you will see at the bottom of your screen. So if you type any questions in the Q&A, if we don't have any questions yet, if we receive any, we'll be happy to answer them. We have a few minutes remaining. I wanted to, say, as some final words, I think historically the relationship between our three countries has been very important. We are next door neighbors. We are, each of these three countries is among the other's biggest three trading partners. So we have a lot of economic interdependence. And we enjoy sharing culture, and I certainly hope that these mutually beneficial relationships will continue and become stronger in many years to come. So I think we did a great job of covering everything because we have no questions. So Raul, Jacqueline, Sophia, thank you so very much for taking the time today. This is, as I said, a topic that has really been interesting me for many years. So I'm thrilled to have moderated the panel. And I thank you very much. Have a wonderful rest of your day.
Thank you so much.
Thank you.
Bye.
Yeah.